She said it with a laugh, not nervous laughter, the kind people use to fill uncomfortable silence, but genuine amusement, as if the entire proceeding were a minor inconvenience, a speed bump on her way to something more important. I've been on the bench for 28 years. I've seen defendants weep, rage, bargain, and plead. I've watched people accept responsibility, and I've watched them deny reality until the bailiff led them away in handcuffs. But I had never seen someone treat a courtroom like a comedy club. Not until Vanessa Kincaid walked into courtroom 4A that Tuesday morning. My name doesn't matter. What matters is the robe, the seal behind me, and the oath I took nearly 3 decades ago to administer justice fairly, regardless of who stands before me. What matters is that on March 22nd in the Superior Court of Belmont County, I discovered exactly how hollow our justice system can seem when someone has enough money to treat consequences like suggestions. Let me tell you what happened when entitlement met accountability, and why sometimes a $500 fine is just the beginning. Fines serve multiple purposes in our legal framework. They punish wrongdoing. They deter future violations. They compensate society for the cost of enforcement and harm caused. A speeding ticket stings enough to make you check your speedometer. A littering fine makes you think twice before tossing trash from your car window. A $500 penalty for a municipal code violation creates real consequence. The theory is simple. Financial pain creates behavioral change. But this theory rests on a fundamental assumption that money actually means something to the person paying it. That losing $500 or $5,000 or even $50,000 creates discomfort significant enough to modify future conduct. What happens when you're dealing with someone who treats money the way most people treat air? That's the question Vanessa Kincaid forced me to answer. The file on my desk.
Buckle up, guys. Today we are going to watch entitlement collide head-on with accountability. What begins as a judge reflecting on decades of courtroom experience quickly turns into something different when a wealthy defendant treats the proceedings like a joke. Her laughter isn't nervous, it's dismissive, setting the tone for a case that exposes a dangerous flaw in how fines work when money carries no weight. This opening frames the central question: what happens when consequences feel?
My desk told me most of what I needed to know before she ever entered the courtroom. Vanessa Marie Kincaid, 29 years old, married to tech entrepreneur Marcus Kincaid, founder of Vertex Analytics, estimated personal net worth of $4.2 billion. Vanessa herself came from money, old money, the kind that whispers instead of shouts. Her father a real estate magnate who owned half the commercial property in 3 states. She'd attended Ashford Academy, then Dartmouth for 2 years, before dropping out to pursue what her social media described as lifestyle curation. Translation: she was an influencer with 1.8 million followers who watched her unbox luxury goods, tour her multiple homes, and offer advice on living your best life that assumed everyone had access to unlimited credit cards. Her primary residence was the Kincaid estate in Riverside Hills, 12,000 square feet, 6 acres, valued at $8.3 million. She also maintained residences in Manhattan and Malibu. The vehicle she drove most frequently was a champagne-colored Bentley Continental GT, base price $240,000, customized with her initials monogrammed into the leather headrests. She had 3 prior citations on her record. Parking in a fire lane, dismissed. Noise violation for a party that exceeded permitted decibel levels, paid with no contest. Failure to obtain proper permits for a home renovation that blocked a public sidewalk for 6 weeks, fine paid. No admission of wrongdoing. Each time she'd simply written a check and moved on. This time she'd done something different. This time she'd broken a law that actually mattered. The incident occurred on February 18th at approximately 2:15 p.m. in the Riverside Hills Historic District. Vanessa Kincaid had hired a contractor to renovate the guest house on her property, a project that required the temporary removal of a 200-year-old oak tree that stood partially on public easement land. The tree was protected under Municipal Heritage Preservation Code, Section 47.3, which explicitly prohibits removal or significant alteration without a permit from the Belmont County Historical Commission. She hadn't applied for a permit. She'd simply hired the contractor, provided the blueprints, and told him to handle it. On the morning of February 18th, a work crew arrived with chainsaws and a wood chipper. By the time a neighbor called the county enforcement office, they'd already cut down half the tree. By the time the inspector arrived, the tree was gone, reduced to mulch and hauled away in a truck. The tree had been planted in 1823. It had survived the Civil War, 2 World Wars, the Depression, and countless storms. It was listed on the county's Registry of Historic Natural Landmarks. Its removal required not just a permit, but a public hearing, an environmental impact assessment, and approval from 3 separate committees. Vanessa's response when confronted by the inspector: "I didn't know. My designer said it was blocking the light." The citation was issued on February 19th. Illegal removal of a heritage tree, a Class B municipal violation, carrying a maximum fine of $500.
From here, the stories shift into who the defendant really is. The court reviews Vanessa Kincaid's background, her immense wealth, luxury lifestyle, and pattern of treating past violations as minor inconveniences solved by writing a check. The narration explains how this time was different, detailing the illegal removal of a protected 200-year-old oak tree. The scale of the damage, the history of the tree, and the disregard for required permits turn a routine code violation into a serious breach of community trust.
Under Code Section 47.3d, she was given 30 days to respond. She hired an attorney from Morrison & Reed, one of the most expensive firms in the city. The attorney filed a motion to dismiss, claiming insufficient notice and lack of criminal intent. The motion was denied, which brought her to my courtroom on March 22nd for sentencing on a guilty plea her attorney had negotiated. Vanessa Kincaid entered my courtroom dressed in what I can only describe as casual luxury, cream-colored cashmere sweater that probably cost more than most people's monthly rent, tailored navy slacks, heels that clicked against the floor like punctuation marks. Her blonde hair was styled in effortless waves. Diamond studs caught the light every time she moved her head. She didn't look concerned. She looked mildly inconvenienced. Her attorney, David Morrison, silver-haired, $3,000 suit, the kind of lawyer who speaks in measured tones, designed to remind everyone he's the smartest person in the room, stood beside her with a leather portfolio under his arm. I reviewed the plea agreement. Guilty plea to illegal removal of protected vegetation. Sentencing recommendation, $500 fine, no jail time. Restoration requirement waived due to impossibility of replacing a 200-year-old tree. It was lenient, extremely lenient, but it was within guidelines, and the prosecutor had signed off on it. "Ms. Kincaid," I said, "please rise." She stood. Morrison stood beside her. "You've entered a guilty plea to violating Municipal Code Section 47.3. The illegal removal of a heritage oak tree on public easement land. Do you understand the charge?" "Yes, Your Honor." Her voice was smooth, practiced. "The court hereby sentences you to a fine of $500 to be paid within 30 days. Additionally, you are required to make a written apology to be published in the Belmont County Gazette, acknowledging the violation and the historical significance of the tree. Do you understand these terms?" She nodded. "I need a verbal response for the record." "Yes, Your Honor." And then she smiled, a small, private smile, and turned slightly toward the gallery where a handful of people sat watching. $500? She laughed softly. "I spend more than that on a single lunch." The courtroom went absolutely still. I looked up from the paperwork. "Excuse me?" She shrugged, her expression somewhere between amusement and boredom. "I'm just saying, Your Honor, the fine seems proportional to the crime, I suppose, but it's..."
The focus then moves inside the courtroom on sentencing day. Vanessa arrives calm, polished, and clearly unconcerned, while her attorney expects a quick resolution. The judge issues a lenient sentence, including a $500 fine and a public apology. That's when everything shifts. Vanessa openly mocks the penalty, laughing and declaring it meaningless to her. Her casual remarks freeze the room, transforming a quiet proceeding into a moment of open contempt that forces the judge to pause.
But it's not exactly meaningful. I'll write the check today. Morrison's face went pale. He reached for her arm, but she continued. I mean, if we're being honest, $500 is what I tip my stylist. So if the goal is punishment. She trailed off with another small laugh. Someone in the gallery gasped. I set down my pen very carefully. Miss Kincaid, this court does not appreciate displays of contempt. I'm not being contemptuous, Your Honor. I'm being honest. You wanted accountability, right? Well, let's be real about what $500 actually means. I felt something cold and sharp settle in my chest. Not anger, at least not yet. Something more focused. Step back, Miss Kincaid, I said quietly. This matter is not concluded. I called a 15-minute recess and returned to my chambers. I sat at my desk and pulled up the case file on my computer. I read every document. I reviewed the photographs of the tree, massive, sprawling, beautiful. I read the Historical Commission's report detailing its age and significance. I read the neighbor's complaint filed by an elderly woman named Ruth Patterson who had written, "That tree was here before any of us. It should be here after we're gone." Then I opened my email. My clerk had forwarded me something, a social media post uploaded 18 minutes earlier from the courthouse steps. Vanessa Kincaid, posing with her sunglasses on, coffee cup in hand, smiling at the camera. The caption read, "Just paid a fine that wouldn't cover a spa day courthouse chic. Justice served, I guess. Court date, harsh tree drama, harsh worth it." 400 comments already, dozens of laughing emojis, people cheering her on, queen energy, living rent-free in their heads. I closed the laptop, then I opened the municipal code book and started reading. When I returned to the courtroom, the energy had shifted. Word had spread. More people had filed into the gallery. A reporter from the Gazette sat in the front row with her notebook open. All rise. They rose. I took my seat and looked directly at Vanessa Kincaid, who was now scrolling through her phone. "Ms. Kincaid, please put that away and give me your full attention." She looked up, surprised, then slid the phone into her purse. "Before I finalize this sentence," I said, "I want to provide some additional context. The tree you had removed was planted in 1823 by Jonathan Patterson, one of the founding families of Riverside Hills. It was a living monument. It provided shade to generations of families. It was home to protected bird species, and it was specifically designated as a heritage landmark in 1978. I paused. Mrs. Ruth Patterson, Jonathan Patterson's great-great-granddaughter, has submitted a victim impact statement to this court. Mrs. Patterson, please approach. An elderly woman stood from the gallery. She was in her 80s, dressed simply, moving slowly with the aid of a cane. Her hands trembled slightly as she stepped to the microphone. "Your Honor," she began, her voice soft but steady. "That tree was planted by my ancestor 200 years ago. My grandmother played under it. My father proposed to my mother beneath it. I brought my children there to read to them on summer afternoons." Her eyes glistened. "It wasn't just a tree. It was a living connection to our history, and it's gone now because someone decided their view was more important than our heritage." She looked directly at Vanessa. $500 doesn't bring it back. $500 doesn't acknowledge what was lost. $500 is a joke. She stepped back. The courtroom was silent. Vanessa shifted uncomfortably in her chair.
After a recess, the courtroom reconvenes with a noticeably heavier atmosphere. The judge reveals Vanessa's mocking social media post made moments earlier and reframes the case around the community impact. A victim impact statement from an elderly woman brings the history of the tree to life, connecting generations to what was lost. Her words strip away privilege and expose the emotional damage beneath the violation, making it clear that the harm can't be measured in dollars alone.
I let the silence rest for a moment. Then I spoke. Ms. Kincaid, I want to explain something about the law. There's a difference between the letter of the law and the spirit of the law. The letter of the law says that illegal removal of a heritage tree carries a maximum fine of $500. That's the statutory penalty. But the spirit of the law recognizes that some violations represent more than just technical infractions. They represent a fundamental disrespect for the community, for history, and for the idea that some things matter more than money. I leaned forward. You walked into this courtroom prepared to pay $500 and move on. You posted about it on social media. You laughed about it. You treated this entire process like an inconvenience to be purchased away. Her attorney stood. Your Honor, with respect, sit down, Mr. Morrison. I'm not finished. He sat. I've reviewed the full scope of the municipal code, and I've discovered something interesting. Section 47.3 allows for an alternative sentencing structure when the defendant demonstrates clear disregard for the law and the community, specifically subsection F, which permits the court to impose restitution requirements, community service, and enhanced penalties when standard fines fail to achieve the deterrent purpose of the law. Vanessa's face went pale. Ms. Kincaid, I am rejecting the plea agreement. I am imposing a new sentence under my discretionary authority. Morrison shot to his feet. Your Honor, you can't. I can, and I am. I struck the gavel once. Order. The courtroom fell silent. Vanessa Kincaid, you are hereby sentenced as follows. A fine of $50,000, the maximum allowable under enhanced penalty provisions. Restitution of an additional $50,000 to the Belmont County Heritage Preservation Fund. 300 hours of community service to be performed with the County Parks and Forestry Department, where you will personally plant and maintain replacement trees throughout the historic district. And finally, a permanent notation on the county registry that any future violations of heritage codes on your property will result in immediate lien placement and potential forfeiture of easement privileges. Her mouth fell open. But that's $100,000 total, I said calmly, plus 300 hours of manual labor, plus permanent oversight of your property. I looked at her directly. You said $500 was your lunch money. Let's see if 100,000 and 300 hours of actual work means something more. Morrison immediately began protesting. Your Honor, this is excessive. We'll appeal immediately. You're welcome to appeal, Mr. Morrison, but while that appeal is pending, your client will begin her community service within 30 days or face additional contempt charges. The financial penalties are due within 90 days. Failure to comply will result in a lien on the Riverside Hills property. I struck the gavel. This sentence is final. Ms. Kincaid, you are remanded to the bailiff to complete processing and receive your community service assignment. As they led her toward the side door, past Ruth Patterson, past the reporter scribbling frantically, past the gallery of people who had watched the entire proceeding, I saw something on her face I hadn't seen before. Not amusement, not boredom, realization. After the courtroom emptied, I sat alone at the bench and thought about what I'd done. Some will say I exceeded my authority. Some will say I let personal feelings influence my judgment. Morrison will file his appeal, and perhaps an appellate court will reduce the sentence. But in that moment, I did what I've always done. I looked at the totality of the circumstances and asked myself what justice actually requires, not what the minimum penalty allows, not what's easiest, not what the wealthiest defendant can absorb without feeling it, but what actually serves the purpose of the law. Vanessa Kincaid walked into my courtroom thinking she could buy her way past accountability. She learned that some things, heritage, history, community, respect, cannot be purchased with a credit card and a dismissive laugh. Will it change her? I don't know. But for 300 hours, While she's planting trees with dirt under her fingernails and sweat on her brow, she'll have time to think about it. And maybe, just maybe, she'll understand that justice isn't measured in dollars. It's measured in accountability. To those watching who believe wealth insulates you from consequence, it doesn't. To those who think a small fine is the worst that can happen, it isn't. And to those who mock the law because you can afford to, remember that judges have discretion for a reason, because sometimes the system needs to remind you that not everything is for...
In the final stretch, the judge explains the difference between the letter and spirit of the law and exercises discretionary authority. The original plea deal is rejected, replaced with steep financial penalties, restitution, and hundreds of hours of manual community service. Vanessa's confidence collapses as real consequences land. The ruling sends a clear message. Wealth does not erase accountability. Like the video, subscribe to the channel, and we'll see you in the next video.